Consent under misconception of fact has to be in proximity of the time of occurrence. That is the news report that I read in a news article today. And for a moment, my eyes went wide up because I thought, is this the kind of jurisprudence that the Supreme Court of India will come up with? Because at first instance, my heart goes out to all those women out there who have, after a long amount of time, gone and presented their allegations against a person after having summoned the courage to do so after a long amount of time. At the same time, I was also reminded of all of those situations where I have seen a man falsely accused of a crime, and that too, the allegation is that this man raped me, this man molested me, this man harassed me some 4, 5, 10, 15, 20 years ago. And at that point of time, my heart goes out to the falsely accused man. So when I actually opened up the article, I went to the judgment, I actually read the judgment of Maheshwar Tigga versus the state of Jharkhand. I realized that this was a case which was instituted by the complainant in the year 1999. The allegations were of rape punishable under section 376 of the Indian Penal Code, 323 IPC, which is causing simple hurt, as well as section 341 of the IPC, which is punishment for wrongful restraint. The allegations of the girl was that in the year 1995, that is 4 years prior to filing her complaint, the accused person, the convict, Mr. Maheshwar Tigga, assaulted her at knife point and then subsequently promised her that he will marry her, and on false promise he forced himself on her and she consented to this. She also stated that he forcibly kept her inside his house for a period of 15 days and forced himself then as well. What you won't find out when you read the judgment is that although the allegation was leveled in the year 1999, the trial court passed a judgment of conviction in the year 2004. I'm sure the appeal was filed instantly. The High Court of Jharkhand took its own sweet time and in the year 2018 decided that the Court of Session was right in convicting Mr. Maheshwar Tigga for 10 years of imprisonment for the offence of rape and certain other years for the offences of causing simple hurt as well as for wrongful restraint. On most days when we discuss any criminal offence, be it of a sexual offence against a woman or any other offence for that matter, even when the person is acquitted, there is no certainty that the person never ever committed the crime. The only reasoning of the trial court always is that there was not sufficient evidence for the prosecution to prove beyond reasonable doubt the guilt of the accused under trial. However, in this case, going through the evidence on the record, which was discussed by the Supreme Court in its lengthy judgment, I can be quite confident that the Supreme Court was right in acquitting the accused person of the crimes that he was alleged of having done. There are multiple reasons. One of the prime reasons was that the complaint was filed by the girl after a delay of 4 years, and that too a few weeks before the accused was about to marry some other girl. Before that, she chose to never come forward with her grievance. Apart from that, the Supreme Court observed that there were several letters which were exchanged back in the day, 1995. Letters were exchanged between the accused and the prosecutrix in which they expressed the deep and undying love for each other, and they also discussed the fact that they were from different communities, because of which marriage would indeed be quite difficult. Apart from that, there were several other things such as the inconsistencies in the statements of the girl when she finally came to court, the fact that the accused was not confronted with all of the prosecution evidence against him, during the time of putting the questions to the accused under section 313 of the Criminal Procedure Code, and several other factors, the Supreme Court said, we cannot let this man undergo the imprisonment. The court also discussed why, in law, consent obtained under a misconception of fact will be deemed to be no consent at all, and therefore an allegation of sexual intercourse on the false promise of marriage would be held to be rape. The court discussed section 90 of the IPC, which says that any consent obtained under a misconception will be deemed to be no consent. But the court also discussed the jurisprudence on this aspect and said that the misconception of the fact must be in proximity of the time of the occurrence and cannot be spread over a period of 4 years. That the consent obtained by the appellant Maheshwar Tigga was a conscious and informed decision made by the girl after due deliberation, it being spread over a long period of time, coupled with a conscious positive action not to protest. The court also went on to discuss jurisprudence evolved over the time, and basically in layman terms said that although there could have been a promise to marry, yet if the sexual intercourse was premised on the deep love and affection by the girl towards the man and not based solely because the man represented to her that he is going to marry her, in that case section 90 of the IPC will not be applicable. The court then went on to acquit Mr. Maheshwar Tigga, but the court also clarified that there cannot be a straitjacket formula and it has to be a case-to-case basis. The court then went on to acquit Mr. Maheshwar Tigga of the offence that he had allegedly committed in the year 1995. In the year 2020, he was acquitted of the offence. However, I can say with certainty that Mr. Maheshwar Tigga during this whole ordeal must have spent anywhere between a minimum of 3 to 5 years in imprisonment while this case, the appeals were going on. To have 21 years of your life being taken away from you because of a false allegation, because of a lover spurned, because the man is about to marry someone else, can be nothing else but atrocious. I am sure after his arrest, Mr. Maheshwar Tigga was not able to get married immediately. I am sure he was suspended from the army. I am sure he must have spent close to his entire fortune and the fortune of his family engaging lawyers to fight out these cases for him. Some of them lost and some of them won. But if nothing else, one lesson we can take from the whole ordeal that Mr. Tigga faced is that in life, any activity that you do, be it commercial, be it sexual, always keep the record of whatever you are doing. Back in 1995, Mr. Maheshwar Tigga kept letters written by him and written by his lover, which helped him get an acquittal after 21 years in the year 2020. You in the year 2020, if you are engaging in any commercial activity, in any business activity, even an activity of a sexual nature, if you have WhatsApp communication, text messages, call recordings, keep those with you. Do not delete that information just because your phone's memory is getting low. And of course, another lesson that we learn is that in India, the criminal justice system is not perfect. If you read the judgment of the Supreme Court, the points that the judges make are very hard to argue with. However, without having read the judgment of the Supreme Court, if you read the judgment of the High Court of Jharkhand, it too makes some very, very valid points. Now you, as a person sitting in your chair watching this video right now, you don't know what the evidence is, you don't know what the truth is. It is only through documentary evidence that you can, on a future date, establish the guilt of a perpetrator or establish the innocence of a falsely accused person. And that is why Mr. Tigga's ordeal can teach us this valuable lesson of keeping all documents intact and also to pray for the best in criminal law, because at the end of the day, the law is what the judge fancies it to be when it comes to criminal law. And of course, get good lawyers. I send a heartfelt prayer to the lawyers in the Supreme Court who argued and got an acquittal for Mr. Tigga.